Let me start off by making clear that you all understand that pursuant to the communications before this hearing and your consent, that there are two cameras in this courtroom that are here pursuant to the Cameras in the Courtroom pilot project, which is a project of the federal courts in which this court is participating. And the video is only of counsel and me, and is being recorded but not being broadcast. And what's done is the tape will be reviewed, and if approved by me, will be then sent on to the federal courts to be posted on the court's website at that point for public viewing.
We're pleased on behalf of the plaintiffs to be part of the pilot program, Your Honor.
All right. Okay. Before us is the plaintiff's motion for a preliminary injunction and defendant's motion to dismiss. Obviously, there is a fair amount of overlap here because the strength of the merits of the case is obviously one important factor that informs the preliminary injunction analysis. So why don't we go straight to the merits question? I have a number of questions that I have. First, Ms. DiEduardo, let me make sure this is a facial challenge to the ordinance.
It is a facial and an as-applied challenge, Your Honor. It's actually both, as set forth in the complaint.
All right. So the as-applied, I guess maybe that's what I'm trying to figure out. Since the ordinance doesn't technically go into effect until February 1st, as I understand it, what is the as-applied challenge? Is there some planned demonstration, conduct, or activity?
Certainly. If I may expand on that, Your Honor?
Yeah.
Certainly. Well, Your Honor, part of what the reason the as-applied would say it's prospectively as to these plaintiffs who are planning on continuing doing what they have been doing to promote urban nudism long before there was an ordinance and long before this even came into the public consciousness. I would also point out that, as we pointed out in our reply, I believe I'm not sure if it's the opposition to the injunction or the opposition to the motion to dismiss. They are, as the court knows, kind of blending together. When this matter was brought back before the Board of Supervisors for the final time on December 4th, a number of plaintiffs, some of whom are in court today, some of whom I believe are still going through security, chose to disrobe in front of the Board of Supervisors. Now, they had done that previously, both at the committee hearing and at the first reading of the ordinance, and the reaction of the sheriffs on those two instances was the same. In other words, what they did was they escorted them from the Board of Supervisors chamber and released them. However, on December 4th, a different protocol seemed to be in place. The sheriffs came in at Defendant Chu's order, placed blankets around these individuals who had removed their clothes, escorted them out, and then detained them. In fact, they were detained for several hours because I went downstairs and tried to get access to my client. I was denied access to do that. Eventually, all but one was released, and they originally tried to file charges against someone who's not a plaintiff. Eventually, though, the district attorney, saw a reason and ultimately decided not to charge her either. Shortly thereafter, and Mr. Hightower can speak to this, my understanding is that he attended the SantaCon, which is, the court may be aware, is an event that takes place in Union Square where a number of individuals dress up as Santa right around the Christmas season. And apparently he was warned by several police officers that if anybody became nude, that they would be arrested. Your Honor, based on those factors...
Let me ask you about the Board of Supervisors event of December 4th. What were the charges? threatened or brought under what ordinance or statute?
Certainly, Your Honor. Well, they didn't actually They didn't actually charge Ms. Taub, who was one of my clients that was detained. She was ultimately released. And they did not charge her with anything. Regarding the other individual, apparently the original charges were supposedly disorderly conduct at a public meeting and resisting an officer.
But not this particular ordinance.
Not this particular ordinance. But I would say, Your Honor, it's not unsurprising, because I don't believe that the city would be that dumb to try to charge someone under an ordinance whose, by its own terms, wasn't in effect until February 1st.
All right, but that's relevant because that informs a question of ripeness and whether or not there is a current as-applied challenge. And if you were suggesting that, yes, it has been applied, it was applied on 12/4, unless there's some indication, either by way of threatened charges or charges brought, that there was an attempt to enforce this ordinance prematurely.
We would, I don't mean to cut off the court, Your Honor. I mean, we would contend that it was a de facto. It was I don't think they were going to be as naive as saying we're going to enforce the statute. But I think there seems to be a definite difference versus the first time when the ordinance hadn't been passed by the Board of Supervisors, and the first time it had been passed on a 6-5 vote versus the final passage. Now, is that coincidental? Perhaps. But without getting into the minds of Defendant Chu and getting into the minds of those sheriffs and going through the discovery process, it's obviously hard for us to determine that, but it's certainly the evidence that's available to us. It seems that something has definitely changed in the minds of law enforcement since the ordinance was passed, and that they seem to believe in, whether that's a misapprehension on behalf of the sheriffs or the police department, it may be the case. But my clients who are here will happily state, if that's what the court requires, that they believe, and in fact are almost certain, that if this injunction isn't entered as the plaintiffs have requested, then the moment February 1st comes around, and if they engage in nude expressive speech, they're going to be cited. There's nothing in the record to indicate they wouldn't be. And there's what evidence does exist, given that whether or not they were, the fact that they weren't actually charged, I think, is not as immediately dispositive of the fact that they were detained and were held for over an hour.
And when you say the plaintiffs want to continue doing what they've been doing, is there any concrete plan to engage in sort of a traditional protest, an organized protest, where the message is singularly clear?
Yes, Your Honor, that's my understanding. I mean, from the plaintiff.
And that's the end of this file. Thank you.